Hello, everybody. I was just about to say happy Friday because this is usually in Washington, D.C., my weekly privacy chat. And it's Thursday night, but it is Friday in Australia, isn't it? So this is happy Friday to our friends in Australia and all those around the world who are following and have been interested in the developments as Australia has been in a process to update its privacy law. And who better to join me for a chat and a conversation about these developments than one of the premier legal data protection minds in Australia, Anna Johnston of Salinger Privacy. Anna recently has been a longtime friend of ours, but recently more formally affiliated with the Future Privacy Forum. It's one of our senior fellows, which means she'll help keep us smart about what is actually happening from a little bit closer of a time zone than some of our team who are distributed around the world. And although I know Anna for many years and really appreciated not only her legal views and her training, particularly this one work she did on de-identification, that's still one of my favorite clear thinking pieces of writing on that. But delighted to finally learn that the name of her firm, Salinger Privacy, I assumed somehow that was sort of a family name somehow or the like, but I finally learned that it is actually after the famous author, J.D. Salinger. So quite an appropriate name, Anna tells me, for a privacy firm. So welcome.
Thank you, Jules. I'm very excited to be here. I'm wearing my my brand new hat as one of your senior fellows dealing with privacy around the world. It's very exciting.
Well, let's share some senior thoughts with our sage audience. It turns out this is a very timely conversation. We organized it a little bit ago, and it turns out the government has been quite cooperative with making sure we have an update to engage with. But let's step a little bit back. I know we've got some folks who do business in Australia or are following developments around the world, and then others who may not know the Australian data protection landscape as well. There is, of course, already a federal law. It is we here in the US that are the only G20 member country without a national federal law, although we kind of have one because California has one, and that's a lot of the country, and who doesn't do business in California? And then we have a few others. So we really have one, but it's at the state level, fine. But Australia has had a law for quite some time, actually. And so this is perhaps the first major update. Give us a little bit of an overview. And there's also a local sort of province level set of, if I recall, when I first met you, I think, or maybe I knew that you had worked in a data protection authority at the local level earlier in your career.
Yes. So, so where do we start? So we do have a federal privacy act. We've had that since 1988. Originally, it only covered federal government agencies, but it was extended to much of the private sector in 2001. The announcements that came out yesterday that I'll go through in a minute are all about reforming that federal privacy act. Really, it's not the first review or update, but it is going to be, I think, the most significant update in more than 20 years. So that's exciting. But separately, the landscape in Australia, because we have a federation, we also have each state and territory has the opportunity. Not all of them have done it, but most of the states and territories have their own privacy laws as well. Usually they regulate the state and local levels of government in that state or territory. So sort of public schools, public hospitals, things like that our state and territory governments run. There is a little bit of overlap in the health space, where there's often some of the states and one of the territories have health privacy laws that also regulate the private sector. But for the most part, the state and territory laws regulate state and territory government. The Federal Privacy Act covers everyone else. So that's the sort of the kind of patchwork legal system that we've got here.
one of the quick mental shorthand tools I think that people who think about data protection law globally have had in hand has been European, most prescriptive with the requirements for a legal basis. Nothing can be collected without a legal basis, and lots of very specific nuance. Consumer protection law model in the US, not truly privacy law, but concepts of fairness and fair dealing and notices and choices from consumer protection law that are applicable when data is involved. And then Canada and Australia have sort of been the intermediate models, perhaps, in that comprehensive, but perhaps not as specifically prescriptive. And this evolution, what was the broader goal? Was it to modernize because it's decades old, influence of sort of GDPR, we must do something about AI, ad tech is a problem, we got to do something about ad tech? What were the political drivers for this update?
So there's been quite a few drivers. The initial driver that kind of kicked everything off in 2019 was a series of reports from our national consumer protection and competition regulator, the ACCC, which is different to our privacy regulator, the OAIC. So the ACCC, so our equivalent to, say, the Federal Trade Commission, was investigating digital platforms. So major digital platforms, Google and Facebook, were the two biggest under investigation from a consumer protection and anti-competitive behaviour angle, or obviously that's the lens that they brought to bear on that inquiry. And part of their final report in 2019 was to first of all recognise the interplay between privacy law and consumer protection and anti-competitive law, recognising that the market power developed by the big digital platforms had been built on a business model based on monetising personal information or personal data, and that you therefore couldn't sort of extricate the consumer protection and the competition angle from the privacy angle. So the solution to remedying some of the harms that were arising for consumers and for small businesses in an anti-competitive sense as well from the digital platforms, the ACCC recommended that our privacy law needed updating in a few particular areas. One of those was the definition of consent, and the role that consent plays, or it should and should not play, in terms of the collection, use, disclosure of personal information. Also, the definition of personal information itself, so what is in scope for regulation by privacy law and what is out of scope. So they made those recommendations, and so they said the Privacy Act should be reviewed. The government at the time, the federal government, accepted that and said, okay, we're going to kick off this reform and review and reform process. And it's sort of got bigger and bigger from there. So that was the immediate trigger in 2019. Since then, we've had an issues paper, a discussion paper, a report that we called the final report, but turns out was not the final report, because then there was another report released yesterday. So we're now up to 4 different reports arising out of this review. Along the way, obviously, this review has become much broader in its scope than just impacts on the major digital platforms. And as I said, because the Privacy Act regulates federal government as well as the private sector, its reach is much, much broader across the economy. So some of the, while the digital platform inquiry was the initial trigger, some of the things that have sort of, if you like, continued to drive the engine of this review and reform process obviously have been developments in AI, concerns about ad tech, GDPR, and concerns or the desire to have Australia be recognised as an adequate or equivalent jurisdiction to Europe. So that's it. Australia does not have an adequacy decision. To our eternal shame, our neighbours in New Zealand have an adequacy decision and we do not. So there's some of the different concerns. And we've also seen a lot of a real shift, I'm going to say, a real shift in community attitudes in Australia towards privacy and the importance of protecting our personal information. And a few of the what's triggered that kind of community attitude change, which therefore leads to the political will to actually do something in this area. A lot of talk about GDPR and its impact, obviously, on businesses in Australia trying to trade into Europe. So sort of 2016, 2018, GDPR was, a lot of conversation. We had the Cambridge Analytica scandal, but also more locally in 2022, so just on 12 months ago, we had a couple of very, very large data breaches. So one involving a telecommunications company, one involving a health insurance company. And between those, well over half the Australian population was affected by two very bad data breaches. So just the telecommunications one alone, something like 50% of the population were either directly affected themselves or had a family or household member affected. And 75% of those people reported they suffered harm as a result of those data breaches. So those big data breaches became huge political stories and an impetus.
So on the note of those data breaches, is there a very substantial security section in the updated law?
So interestingly, the original kind of terms of reference were, well, we're not going to do too much around security or notifiable data breaches because we already introduced a notifiable data breach scheme. So we had, as I said, the Privacy Act hasn't been static since 1988. So we introduced a notifiable data breach scheme in 2018. So originally that any kind of review around that was out of scope, but because of the data breaches, it sort of got brought back in. So we already had, in that immediate wake of that, because that was such a big political story 12 months ago, the Privacy Act, some of the issues being looked at were sort of fast-tracked. So the Act was reformed last year, just before Christmas, to massively increase the fines, so the financial penalties that can be levied. So it went from a $2 million fine to a $50 million or 30% of turnover or 3 times the count of profit. So depending on how the currency exchange rate's going at the day, potentially Australia has bigger fines now than the GDPR does.
So let's jump into some of the dramatic stuff. If part of the concern was big tech, part of big tech is advertising. Companies that do business globally always want to know, well, do I need a consent banner and cookie pop-ups here, or am I not allowed to do targeted ads? Or and that was part of the debate. Where does what's the end result in terms of the current behavioral advertising model? Will it need to change? Are we going to see pop-up banners? Are there better opt-out rights? What do they end up doing when it comes to personalized or targeted or just ad tracking in general?
Yeah, so what was announced yesterday was the Attorney General's response to all the recommendations from the review. So it's the government of the day, what they are committing to actually do. So they're proposing to bring a bill to Parliament in 2024. There's some things they've said will definitely be in, others they've agreed in principle and will be subject to further consultation. And the ones that you've just talked about, say impact on behavioural advertising, is still subject to further consultation. But at least what has been agreed in principle is there's quite a few different parts that you have to sort of pull together to understand what the impact will be overall. So one of the themes to come out of the report is to try and reduce the reliance on consent and move away from a notice and consent model. So we know that people have consent fatigue. They hate the pop-up cookie banners. We know about dark patterns. We know that people don't feel like they necessarily have a choice or control anyway. So one of the things, or one of the proposals that the attorney has agreed to in principle, that is important here and that all interrelate. One is that the definition of consent will be, if you like, upgraded to mean it must be informed, specific, voluntary, but also unambiguous. We've got a proposal to introduce privacy by default. So that's trying to move away from dark patterns. We have as well a proposal to introduce an overarching fair and reasonableness test. So at the moment, a bit like the GDPR, we've got sort of the lawful basis for collecting, using, or disclosing. We don't use quite the same language. We don't actually talk about, we don't have 6 grounds for lawful basis, but effectively that's what we have. We have rules around collection, use, and disclosure. One of the proposals is to keep all of those rules in place, but then put on top of that a kind of a filter that's the fair and reasonable test, meaning you cannot pass go. If you're trying to track someone or send them a targeted ad, for example, you cannot collect their data or use it or share it with a third party unless you pass this fair and reasonable test, as well as you've still got to meet your lawful basis for doing those things. And importantly, that fair and reasonable test applies regardless of whether or not you have the person's consent. So you can't consent your way out of the fair and reasonable test. You can't get someone to click a banner saying they agree to something unless you've already demonstrated that what you're asking of that person or what you're planning to do was fair and reasonable.
And help us understand, just in terms of the legislative process, it's a parliamentary system. So when the government, in the US, if the administration said, well, they're proposing this, we'd say, well, yeah, but who knows what Congress is going to do, and they'll change it and they'll, go their own way. The government and the majority, party saying this is our plan, Parliament can still tweak things around, but it carries much more heft. And so this is a proposal to be taken seriously.
Yes.
There may be language to be massaged, and the minority party gets something in, and perhaps and so forth. But we shouldn't expect to see dramatic departures. Is that?
I don't think so. I mean, this review began under the former coalition or conservative-leaning government. It's continued under the current Labor or left-leaning government. Privacy is, especially because of those big data breaches, it's very much a bipartisan issue. So our system of government, it's more like the British system of government. The government controls the House of Representatives, the lower house. The bill is usually sails through the lower house. In the upper house, they have independents and crossbenchers and the opposition to negotiate with. So they don't have a majority in the upper house. So they do need to negotiate with other parties. So that's usually where you see any amendments coming in, is in the Senate, the upper house.
And given
but
that,
as I said, expecting sort of bipartisan or cross-partisan support for these reforms.
And given that the notion of adequacy was sort of front of mind, did the drafting seek to address some of the gaps that people are aware between the current act and some of the priority essential equivalencies of GDPR?
Yeah, this is one area where I think it's a bit of a mixed bag. So one of the real stumbling blocks to why Australia has not received an adequacy decision so far, not that Australia has even asked in almost 15 or so years, but the reason we didn't get an adequacy decision then was because of some of the carve-outs from the scope of the law. So one of the most significant carve-outs is an exemption for small businesses, so businesses with less than a $3 million annual turnover. So that exemption is proposed to be abolished. So that's really big news. A huge proportion of the economy is driven by, employs people in that sector is the small business sector. And, when the laws were drafted in the late 90s, it was kind of assumed that if you're a very small business, you wouldn't have the ability, or you didn't pose the same kind of risk of creating privacy harms to individuals. Now that justification has gone. I mean, that's why that decision was made when they were drafting the law in the 90s. Let's not impose this compliance burden on small businesses because they're not the ones that we're worried about. But now anyone can start a tech startup and start scraping information off the internet and creating, facial recognition algorithms. That kind of the old justification for why we had that exemption is gone.
Speaking of exemptions, another one that's often debated, California covers in some part employee data. The other state laws that have been passing in the US don't cover employee data. GDPR obviously does cover employee data in a very significant way. In your write-up, which I believe we are posting or posted a link to in the comments, you flag that it's a bit unclear. It looks like they've sort of punted that for now, and further consultation to determine whether employee records are covered. What about the big issue of what's actually covered in terms of what is actually personal? Anna reminded me before we started talking that the last time we did a session like this was to discuss a paper she wrote arguing for a broader definition of personal information in order to provide something that actually addresses potential harms. What indeed did they end up doing? What's the definition now, and how do they propose to broaden it?
So the definition is not too dissimilar to the definition in, say, the GDPR, in the sense that it talks about personal information is within scope for the privacy law if it's information or opinion about an individual who is identified or reasonably identifiable. But that phrase, reasonably identifiable, is what has been difficult to interpret and apply and understand. There's plenty of argument about it. And what we haven't had to date, and what we hopefully will have with the government's commitments yesterday, is an understanding that it is the phrase reasonably identifiable can encompass people where they can be, in the GDPR's phrase, singled out, in my word, individuated, or disambiguated, recognised as unique individual within a crowd without necessarily needing to know their identity. So what we've got now is a law that says personal information includes where someone is reasonably identifiable. That's what the statute says. A regulator says reasonably identifiable doesn't necessarily mean you need to know the identity or name of the person. It means if you can distinguish them from others. What we've seen now is the government saying, well, we agree with the OAIC's position and that this is the direction that the law reform should be going in. One of the reasons I've been arguing for this kind of change for many years is that we see a lot of privacy invasive behaviour, particularly online, where companies have either escaped regulation or at least are arguing themselves and hope that they're going to, win the argument if it comes to it with the regulator, that, well, no, we can track what people are doing. We can link up their data. We can build these profiles because we don't actually know the person's name. We can track them across the internet. We know what they're doing and we can message them. We can contact them. We can try and influence them. We can try and sway elections by messaging them. We can try and get them addicted to gambling. We can try and sell them all sorts of things, but we don't need to comply with the Privacy Act because we don't actually know the person's name. Now, that argument, I think, again, in terms of looking at the kinds of harms that can arise for consumers and citizens, those harms can arise whether or not the company or knows the person's name, and therefore the law should protect that kind of data, whether or not the person's name is included. So that's, to my mind, a really significant development. We know that jurisdictions like California, for example, already have definitions that are broader. So from memory, the Californian definition allows, it might be information connected to a household or a device, not necessarily down to an individual's identity. So that's the kind of direction that the Australian law is now moving, it would appear.
Yeah, look, I think there's a big intellectual broadening, which is perhaps why you initially wrote it up as sort of a more scholarly paper. you know, I'd argue that I can see some of those same harms happening whether or not I can single you out. I can deal with a large group. So if the concern is personalization of what one is being provided, or these sorts of practices, they're broader than personal information data protection concerns. They're really, we don't like messages that are too intensive, given the amount of sort of data that might be unfair or the like. But that there are other areas where the use is actually a positive one or a preferable one, and where some of the challenges of data protection, being able to delete or give access, or the transparency, doesn't map well when there isn't a link back to an identifiable user to give some of those rights. So I'm eager to sort of see whether the bill or the next steps, track. I've sort of argued that we should do more to recognize types of pseudonymized data that could and should have different levels of protection given the kinds of uses and the kinds of rights that are feasible given those types of data. Maybe that creates way too much complexity, and we need to just deal with fitting it into one box or another. But well, kudos for winning the argument, and it certainly aligns a bit with the European approach. But I think ends up creating problems for the statisticians who bring, one framing of how to, avoid identification. But quite interesting. What are some of the other changes? Automated decisioning and AI. Is this an AI bill as well? We've argued that you can solve not all the AI problems with data protection, but data protection does already grapple with many of the AI relevant concerns. How do we see automated decisioning, AI profiling? What's going on there?
Yeah, there's a bit of a call out around automated decisions and introducing a better right to transparency. So again, picking up from a theme from the GDPR, a few new individual subject rights, the right to erasure, the right to de-indexing, and the right to obtain meaningful information about automated decision makings with substantive legal effects. For the most part, though, the existing law, the proposed changes are technology neutral. So it's not going to be a sort of AI, certainly not going to be an AI specific bill. Many of the reforms will be relevant to companies either developing or deploying AI. That right to sort of greater transparency, meaning meaningful information over automated decision making, is it's not a bad thing. In my view, it doesn't go nearly far enough. But we have separately another government department is conducting a review at the moment about appropriate regulatory models in relation to ethical and responsible AI. And they're very much talking to each other. And there's been a good recognition, I think, recently in Australia that we need to, if we're going to deal with AI, we need to make sure these privacy reforms all get up and are embedded. And separately, we need to ensure that our anti-discrimination laws and our consumer protection laws are all working as well as possible, and our copyright laws. So it's all about actually strengthening and enforcing some of the laws we have, instead of pretending that AI is utterly unregulated. It's not the Wild West anyway. And then, is there something sort of AI specific that should be brought in on top of those or beside all of those other laws?
I want to try to get to some of the questions, but before I do, a couple of quick points here. there are mandatory privacy impact assessments, but only for high-risk activities. Do we have some guidance on what are high-risk activities?
Yeah, so we already have mandatory PIAs for the federal government agencies. What's proposed is to bring that rule across to cover the private sector as well. So the OAIC, Office of the Australian Information Commissioner, which is our national privacy regulator, already publishes guidance on what constitutes a high risk or high privacy impact activity. If you like something inherently high risk, the point is that if you do your privacy impact assessment, the idea is to mitigate those risks as much as possible. So the guidance that we have from the OAIC it's fairly similar to guidance from the EDPB under the GDPR for DPIAs there. So things like, actually use of AI is one of the things that gets called out, or automated decision-making with substantive legal effects. There's also factors like, so the volume, it might be the volume of information, personal information being processed that would tip you into that category. It might be the nature of the information. So maybe it's information about children or other vulnerable populations, prisoners, Indigenous people, and so on. It might be the nature of the technology, as I said, AI. It might be the nature of the use case, surveillance, law enforcement, things like that. So we do already have some published guidance on that question.
Mandated senior employee to hold privacy responsibility. So not a DPO with sort of this independence concept, but a senior chief privacy officer type role. Is that fair?
We think so. So again, this is something already mandatory for federal government, and it's about extending it to the private sector as well. It will, however, be interesting to see how that one plays out in the context of abolishing the small business exemption. When the government says they've agreed in principle, they have said, well, we do still want to consult on some of these things. We want to make sure that the compliance burden on small business is not too great. So maybe some of the requirements will not be applied to small business. So this is one of this requirement to have a senior employee designated as responsible for privacy management. That's one of the things I would expect. I wouldn't be surprised if there was a little small business carve out from that requirement.
And I guess the big news in ways is a direct right of action for individuals to actually go ahead and litigate and sue for damages, which in some cases, is it a collective right sort of a thing? I mean, can we expect to see giant class actions and, plaintiffs' lawyers and all that sort of thing that have been common in the US and are now starting to become a factor a bit in Europe?
So we've got a couple of different reforms here. So one is a direct right to sue for breaches of the Australian privacy principles, so that this forms the backbone of the legal obligations on organisations. So what's different about that is at the moment we, as individual consumers or citizens who may have a complaint, we have to make that complaint to the organisation. If we're not happy, we go to the regulator. The regulator usually mediates. And at that point, first of all, the regulator, because of funding constraints, typically is it's a bit of a bottleneck. Can't manage the complaint load they have, and you can only then have your day in court if the OAIC actually makes a determination and then you appeal against it. The direct right of action, the idea is if you're not happy with what's happening at the OAIC, you then have the right to apply to the court and seek enforcement of compliance with an Australian privacy principle by that regulated entity. So that's one thing, and we may see class actions there. The other is a statutory tort of privacy, which would be expected to go much broader than just the APP. So the APPs are just about personal information, whereas a statutory tort of privacy might incorporate things like, bodily privacy, surveillance by the media, and so on. One of the reasons a statutory tort of privacy has been recommended over and over and over again by multiple law reform inquiries, bipartisan committees, parliamentary committees, and so on for decades now. One of the reasons is that we need that kind of statutory tort of privacy is to deal with media intrusions into privacy, because one of the other big carve-outs from the Privacy Act is we have a carve-out for political parties, and we have a carve-out for media organisations when acting in the course of journalism. So, and the government is not proposing to touch either of those two broad exemptions, which is disappointing to privacy advocates and Australians who might have expected better action there. But on the flip side, the media might expect to be sued directly by individuals who suffer harm. That statutory tort is only for serious invasions of privacy. There's quite a high threshold to be met. So that's where we might see, a bit like the law of defamation, it may really only serve the purposes of people with deep pockets. So perhaps celebrities might have the kind of money needed to go and sue for a statute in terms of a statutory tort of a serious invasion of privacy. Whereas the direct right of action may be more for people who've been, less wealthy people who've been harmed by conduct that they believe breaches the Privacy Act.
A couple of quick questions. One of our friends, Alana, who I believe is in Singapore, asking, I think, about the definition of personal information. Does this revised definition perhaps extend broader than the GDPR? I'd say, well, let's see what the EDPP actually has to say about the definition of personal information, which we expected an updated EDPP opinion. My understanding is that between the Breyer case and then this recent EDPS case, which have opened up some possible margin for pseudonymous data or data that might be personal to one party but not to others, that slowed down what was an almost final opinion, because suddenly the courts were on the move. I think now that the EDPS has appealed, I don't know whether they're going to wait. I don't know how soon we'll see a result from that appeal, but the courts might give us an answer that the EDPP will therefore obviously have to take into account. But Anna, your take on how it I'd say it tries to match what has been the accepted understanding of the GDPR as per the previous Article 29 Working Party and EDPB thinking, which I think is in flux.
Yeah. So, I don't think the intention is to go beyond the GDPR, but to clarify. And we've also had, as I said, we've had decisions from our regulator saying that information which allows an individual to be singled out, which includes pseudonymous data, if they can be singled out and acted upon in some way, that is within scope. I think the point of the statutory change here is just to clarify that is the case, that you don't need to know someone's name or their identity in a sort of legally verifiable, this is what their driver's license would say kind of sense. The broader issue of how do you then tackle the privacy harms from pseudonymous data or de-identified data, a lot of that still needs to be worked out. So some of the proposals that have been, again, agreed to in principle, but the government has said, well, we need to have more consultation about how do we draft these, how is this going to work in practice. So they've kind of agreed on what the policy intent is, particularly around direct marketing, online targeting, trading of personal information, but they've got to bed down the definitions carefully to make sure that there's not any kind of unintended consequences. And Jules, I know you called out earlier, for example, statisticians and researchers may well be concerned, but at the same time, we have some research exemptions, and one of the other proposals agreed to in principle is to actually broaden out those research exemptions. So I think the policy intent is to make sure that the scope of the law, so because everything hangs off this definition of personal information, so get that fairly broad, and then let the privacy principles themselves and the fair and reasonable test and some of the exemptions to do the heavy lifting in terms of saying, well, research in the public interest, good, intrusive online tracking of people, bad. So we have to figure out how the rules will apply. But the first the key thing, I think, is to make sure that the definition covers all of those use cases in the first place. Otherwise, you're not going to be able to, say, regulate online behavioural advertising at all if companies can continue to say, well, we don't know whether this person's called Sally Blogs or not, but we know exactly what she buys and where she goes and what her preferences are, and we know how to influence her and target her.
Although I would argue that the companies that have tried to make that argument aren't making a credible de-identification argument, because no expert would say, hey, if I have a individual record and I have thousands of different data points, and oh, by the way, many others use that same identifier, and I don't really have control over what they do with it, and it's collected in hundreds of places, that there isn't an actual identification risk. I do think that there are now, so those who've simply argued, well, it's a cookie, I don't know the name. Okay, but 100 other companies do, or there's thousands of points of location data. So I think the use cases that end up being interesting are research, or whether it's actual qualified as public interest research, pharma key coded data, data sets that are controlled. I create a one-time identifier for a certain data set, but I do want a longitudinal file. So this user is singled out because I have 7 or 8 other data points, so that I can, analyze and come up with perhaps an aggregated, at the end of the day, set. So that's, I think, sort of the place where, again, it intersects with this notion of, is it absolute, or is it the fact that somebody has legal and contractual controls, around it, and we can guarantee that an attacker actually won't find an identity, but I can study this data set in a way that lets me learn based on unique longitudinal records. But anyway, we don't want to wonk out too much. But how many people enjoy talking about that? So I can't resist when I have you on it. But
we have a lot of clients in the research space, so we get to talk to them a lot about these issues.
Awesome.
And to me, it's all about appropriate risk management. Identifiability is on a scale. I don't think it's black and white. I don't think there's a bright line between who's identified and who is not. So it's all about sort of figuring out roughly where you are on that scale and applying the right risk management kind of strategies to
and the ethics of which, right? When assessing that harm, and also assessing the utility, which might be advertising, so maybe we don't care, but it also might be safety or transportation or identifying bias. So having that, I've almost argued it's almost an ethical assessment when you make the decision as to what the risk utility trade-off is. Sometimes it's just money versus efficiency, and so if there's an impact on human rights, it loses. And sometimes you might want to make the argument, I don't know, you're solving climate change and the risk is low, but it's not nothing, and it also needs some additional data that could create an identification risk, but actually provides profound utility to a socially important goal. So let me bring in one more question that I see flagged, and then we're going to let people go about their days. Two of our attendees asked about, what does fair and reasonable mean? Do we have guidance? What can you tell us about that?
Yeah, so I think this is going to be a really interesting thing to see play out. The idea is that we want a legal test that will kind of be flexible over time. We don't want to, say all AI is unfair or unreasonable, or facial recognition is always good or always bad. You need to be able to recognise that what's fair and reasonable depends on the type of technology, the type of use case, the kind of safeguards in place, the organisation that's handling it. So in the final, so-called final report from the beginning of this year, which had a whole bunch of proposals, which proposed this fair and reasonable test, that report does list a number of factors. So the idea is that the legislation itself will introduce the test and list some of the factors to consider, but that list may then be supplemented with guidance from the regulator, which can then obviously reflect changing technologies, changing use cases, and changing community attitudes over time. So there, I think that idea has come a little bit from Canada and their idea of having some no-go zones. So, you know, the regulator can kind of take the pulse of the community over time and start to offer guidance. And, you know, guidance can be updated faster than legislation can. So that hopefully keeps things kind of flexible and current. So there is I think there's going to be a link to one of my blogs in the chat. You can link back from there to the earlier reports and our earlier blogs where we've listed out what some of those factors are. But as I said, there'll be some in legislation and then supplemented with guidance from the regulator.
Is there any, and this will be our last question, is there any update on the conducting business in Australia test in the context of cross-border data transfer?
So I'm going to say this is not an area I am an expert in. There's been a few changes already. So our privacy regulator was fighting Facebook all the way to our High Court, which is the highest court in Australia, over the question about was Facebook actually carrying on a business in Australia. Meanwhile, and Facebook has now lost that case. They were found to have the appropriate sort of Australian link to bring them, to require them to comply with the Privacy Act. And this is all still in the context of the Cambridge Analytica scandal. So that case, 5 years later, still dragging through the courts here. But meanwhile, as I said, when our Act was reformed just before Christmas to introduce the big new penalties, the section about the Australian link was also reformed, which made the whole argument from Facebook moot anyway. But there is yet another proposal to sort of tweak that a little bit. I'm not an expert in corporate law, so I'm not going to try and answer that question off the top of my head. But if you have a look at the proposal itself, that will give you a bit more detail. But we do already have, I can say, like the GDPR, like many other laws, we do already have extraterritorial effect, and the intention is for that to continue.
Really enjoyed talking about this. I suspect we'll talk further because, as you explained, until we have a final text actually rolling its way through the Parliament, we have lots of information about the likely direction, but the devil will be in the details of the final text. But those of you following now have a good idea of what to look for. Vivian, thanks for flagging that we have a couple of pointers in the proposal about fair and reasonable expectation of the individual, the type, the sensitivity, and the amount of information, whether it's reasonable, necessary for functions, typical to some of these concepts in GDPR or even in some of the FTC's jurisprudence. So thanks so much, folks. This video hangs around here on this channel, on this page. LinkedIn uses its automated algorithms to then try to determine who else in my network is interested. So we'll see it being exposed to usually a couple thousand people over the next couple of days. So keep an eye in the comments if it's a conversation you want to continue following. We then post it on YouTube. It gets turned into a podcast. It's unavoidable. We're targeting you everywhere, and only with fair and reasonable goals of helping us all have good conversations about the complexities of data protection law. So thank you, Anna, for being one of our guides through the complexities of data protection law. Enjoy the rest of the day in Australia, and a happy Friday to those in your zip code. Everyone else, stay tuned for next week. I don't know if I've chosen a topic. Actually, I may actually even do Friday noon if I have the zest for it, because I think there's a lot been going on. Not only Australia is on the move, so perhaps those of you who have the stamina and aren't tired of me already, tomorrow U.S. Eastern, we'll perhaps take a look at some of the other big developments. You know what? I might talk about Professor Dan Solov. Many of you know, one of the most cited legal academics, friend and a neighbor of us here at George Washington University, wrote a piece about some of the First Amendment issues that were raised by the judge who struck down the California Age Design Act. We didn't mention there is a children's type code, modeling a bit on the UK. Well, the California one just took sort of a blow from a judge who made a number of arguments saying that our First Amendment creates some serious points of interference. Professor Solov analyzes that and finds that, well, in some places that's fair, and others the judge would be striking down every obligation to do a privacy impact assessment if that's forced speech, and a bunch of other areas. So might be interesting to take a look at that piece and maybe chat about whether that case, if it stands, it's on appeal, is a blow to some of the privacy regulation that is spinning here in the US. Anna, thanks all of you who listened and joined, and Megan and FPF Comms team, thanks for making these things happen.
Thanks for having me.
Bye all.